Member for Vieux South.
Mr. Speaker, I just want to add a few words. I intend to be relatively short. I agree fully with the member for Grosley that this legislation has had a very lengthy gestation period. It's been several years in the making, and before it's got to this stage, I know it has gone through many permutations, a lot of changes, and I think that it is to the credit of the drafters of the bill that they have been able to produce this final text, because it is generally very well drafted, and the language, I think, is exceedingly clear. So it's very accessible law. And I think some commendation in that regard is deserved. Having said that, Mr. Speaker, this is not to say that there were not omissions or issues. And I, for one, although I would not have certainly made an issue now, I, for one, would have been happy to see in the Child Justice Bill a section or a part of the bill dealing with the matter of adults who use children to commit crimes. I know that the criminal law handles some aspects of criminality in that regard, but there are a whole range of crimes that children are made accessories by adults, and the adults escape relatively unscathed in these matters, so that the whole range of possible criminal offenses that can be committed by parents, by relatives, outside of the traditional offenses that we know of, for example, like incest and rape. I'm actually talking about using children to commit crimes, whether, for example, as lookouts, or to carry firearms, or to carry drugs, and those matters. So I think that is one omission, but clearly I don't think that omission should have stood in the way of this Child Justice Bill. I think these are matters that we'll have to handle in the future. That being said, there is one part of the Child Care Protection and Adoption Act that I just want to draw attention to, because I think a slightly different approach could have been taken. And I agree totally with the member for Grosley that the whole focus adoption law has changed, that unquestionably the child is now of paramount importance in the legislation, that all individuals and agents dealing with adoption issues have to treat the child as a paramount consideration in all the deliberations that take place. And I think this is certainly a welcome approach. I think an effort has been made to keep lawyers away from adoption, to ensure that the lawyers do not colonize or take over adoption issues. And I think that is correct. That really is correct. And in this instance, what has happened with this legislation here is that the division that has responsibility for child care takes over the dominant role. And herein lies the potential problem, because I don't think it necessarily makes the approach immune from legal attacks. The member for Grosley, in presenting the bill, did suggest, for example, that the court here was a family court. I think it would have been far better. That would certainly have been desirable if we had a really established family court and they would have had jurisdiction. In fact, the definition of court here means a district court. And I thought that was very unfortunate myself, that really matters of adoption, if it does reach the court, should not really be handled at the district court level. But maybe it's one of those little omissions. I don't know. Maybe it was deliberate policy, but perhaps again in time these matters could be dealt with. The institutional arrangement I'm concerned about is in the adoption committee. And I think a slightly different approach could have been taken in this regard, and I'll explain why. Clause 73 establishes an adoption committee. It says the adoption committee shall assist the minister in giving effort to the provisions relating to adoption in this act. And this act places the minister at the center of the decision making in many ways, because if you look at, for example, Clause 80, The adoption committee shall report to the minister on the conduct of the business activities and other affairs of the adoption committee. In another forum, I might have had huge problems with this, and I think no minister would really want to get as intimately involved in these matters as it is being proposed here. Certainly, it's a kind of decision-making the minister should treat with arm's length. But it is clause 73, subclause 3, that I'm concerned with. It says that the director will be the chairperson. The minister shall appoint the following persons as members of the adoption committee. A, the director, who is the chairperson. I think this is unfortunate because what it does, it makes this legislation pregnant with conflict. I'll explain. The legislation seeks to place the matter of child care protection adoption squarely in the hands of the ministry that has responsibility for these matters. But the reports as to the children who are eligible for adoption, these social surveys that have to be undertaken, the assessments that have to be undertaken, are all undertaken by that department. So when an issue of adoption is being determined, the director is sitting in the chair and receiving reports from the very same department that she's responsible for. Now that certainly can't be right. I mean, if you turn your attention to section 89, just to grasp the simple point that I'm seeking to make, in section 89, you can see some of the duties of the department prior to placement. It says, before a child is placed for adoption with a prospective adoptive parent, the division shall provide counseling and information on adoption and alternatives, etc., and it goes on and on. In other words, the preliminary work on the question of adoption is being done by the department, by the division, under direction of the director, because she's in charge of the division. So the director then has to sit to consider these reports as chairperson along with other persons, but they're reports from her department. Now, that kind of scenario will, I think, in time present some very challenging problems and will certainly be a good breeding ground for lawyers to explore in due course. Because very clearly, you're going to have the real potential of conflict of interest of someone who is supposed to be giving direction to her staff members about adoption issues, but she's sitting in judgment together with the committee. My personal view, Mr. Speaker, is this. The director should be a member of that committee. Should be. But only to present and defend the reports of her department. Rather, I think a more sensible approach might have been to make it possible for the director to be a member of the public, for that matter, and I'm neither here nor there. It could have been a lawyer, let us say, of 10 years standing, although there is a lawyer from the AG's chambers, but it is somebody from the society who has the requisite qualifications and interests in the issue of child care, child protection, etc. So my view is I would have removed the director as chairperson, replace the director by a member of civil society, but leave the director on board. Because someone has to present the reports from the department regarding the prospects of adoption of the subject child. I mean, the committee says the adoption committee is made up of the director, a family case worker, fine, a pediatrician, crucial, a mental health practitioner, crucial, a representative from Attorney General's chambers, no issues with this, because Attorney General's chambers have direct interest in adoption matters. And then it says one representative from a non-governmental organization. I don't have any difficulty with this, but I do think what could be done is to say that director who shall be a person with experience and qualifications or whatever in child care, child custody, but leave the director on board. I think this might have been a far more useful approach, but as it is here, as it is proposed here, it can produce problems, undesirable problems, and that it will be a potential breeding ground, I suspect, for disputes if this is retained in this manner. So, Speaker, that's all I just want to say about this bill. I will not detain members. As I said, a bill with a long gestation has been in draft for a long, long time. It is good it's finally made its way to Parliament, and overall, I think it is a well-drafted bill. Thank you, Mr. Speaker.